Yeah,
Hi, we are recording,
that's perfect. That's fine.
just so that you know. And I will make you a host. So, because do you want to control your slides or do you want me to?
No, I think I can. I think
Okay.
it, but am I just speaking and there won't be anybody there?
Might be someone on. So if anyone's listening to this, we know it's in the early stages of Club 62. We'll wait until the start time of 3 o'clock. But this way, everyone knows that this will be saved for future use in the library.
Okay.
And I will go over that in a few minutes once I introduce Bruce to everyone.
All right. And then how, if there are questions, you'll navigate them through the chat
Absolutely.
and as appropriate, you'll interrupt me.
Absolutely.
Okay, that works.
All right. I made you a co host, so you should be able to use your slides.
Should I share it? Should I bring it up?
Yeah.
Okay. Thank you so much.
Oh, perfect.
Almost perfect. It's just,
Oh, it's getting there.
how's that?
Yep. I love it.
Good?
Yep.
Perfect. Okay, perfect. I guess I shouldn't answer this, right?
Probably not.
Probably not, or do we have 5 minutes if I go on mute?
Oh, yeah. Go on mute.
Hi, Sarah.
Okay, Bruce, so if you're okay, we will get started, knowing that for all purposes, most likely it's just you and I on the call, but that this is being used. Bruce will be featured as the first video in the new Club 62 library. So hi, everyone. I'm Holly McDonald. I'm one of the contributors for Club 62 Plus, and this is my client and my guru, and I call him just about everything. Bruce Sham, who is a special needs advisor that I highly respect. He's a national level speaker, sought after by many families because Bruce goes through this every day, not only with his clients, but personally with his own family having a special needs family member. And I always say with Bruce that I can hear his presentations and I look at them all the time. And I can tell you that after this, I'm still going to learn at least one new thing, and I'm going to text them like, wow, it just hit me about this. So please know that Bruce is always available for you to reach out. And Bruce, would you like to share before we get started the best way to reach you, even though it is on the website? Do you prefer people to reach you via email?
Email or phone. My phone
Okay.
number is on the slide here, and we will make sure that Holly and Melissa have the slides.
Yep.
Either is fine.
Okay. All right. So everyone, let's get started. And thank you to Bruce Sham. Bruce is the founder of Special Journey Solutions. He has been a long time special advisor, as we mentioned, and I'm sure Bruce will get into a little bit about his history. But the reason Bruce, Melissa, and I picked this as his first presentation is that many of us know someone with special needs. And Bruce can tell you much better than I what special needs is defined as, because when I first met Bruce, I thought, oh, it's just this one thing. And oh boy, have I been educated. That is more than one thing. And that it's very important, and Bruce knows from the personal side, that it's that you plan and you have that peace of mind for your special needs loved one. And Bruce, I'm going to hand it off to you with anything you'd like to share, and then get us started on how caregivers can plan to leave that legacy and protection for their loved ones with special needs.
Okay, thank you so much, Holly, and thank you everyone for being with us today. And I think Holly made a very, very good point. Special needs is not just someone with an intellectual or physical disability anymore. Special needs post-COVID, think of all the people that are suffering with emotional, behavioral, just isolation issues, depression. We have seen these stats just go through the roof, having been isolated for 3 years. Special needs could be an alcohol, drug, or addiction problem. One of the things that really, really scared me was when we learned about some of the addictions that people did pick up also during COVID, things that actually stayed with individuals that prevented them from going back to work. So thank you, Holly, for bringing that up, because that is very true, and we've seen it a lot as we've worked together. That special needs could be a debilitating illness. I could be developing Parkinson's disease or Huntington's disease or ALS. These are all special needs scenarios where special planning needs to be taken into consideration. 1, so benefits can be accessed. 2, so that benefits are not lost. 3, so that other family members are not disinherited or potentially left with nothing, no resources. So we're going to get started. Obviously, we do have our disclosure. This should not be considered tax or legal advice. We work with accountants, we work with attorneys, and that is very important when we are working together to make sure that, I know we have people that will be listening in from all over the United States. We are located in the Pennsylvania, Philadelphia area. We are licensed in every state. We have advisors in every state. But every state, even though Medicare, Medicaid, they are federal programs, they are administered from the state, and it may be different in every state. Even when I talk about ABLE accounts in a little while, they are even treated differently in the different states. So it's very important that, we just, again, use this disclosure, but with the hope that when you do reach out, make sure that we talk about where you're located and what state that you are in. Because as I said, every state is going to look at this a little bit differently. So what I want to go through today is a little quiz. And again, I don't expect anybody to answer, but it's really more for thought provoking. But we are going to talk about government benefits. We are going to talk about the different types of special needs trusts. There are not just one or two, there are almost 4 different special needs trusts. And they are also referred to differently depending upon where you might reside. So I may be talking about a supplemental special needs trust, and you may say, well, I have a D4A trust, or I have a self-settled trust. Again, there are many different terms for similar documents. What we are going to be particularly concerned about is that they are drafted properly by a special needs or elder care attorney. I know that many folks will always say to me, oh, we have minor children. We had trusts set up for our children, when they were born. But if those trusts give discretion to the child when they turn 18, 21, 25, like we typically see for neurotypical children, it will not be treated as a special needs trust or a supplemental special needs trust. And our child with special needs, or that child who's receiving government assistance, could be very compromised. Okay, a week does not go by when we do not get a call from a sibling of an individual with special needs saying, hey, my parents died, and we just got a letter from Medicaid saying that my brother's insurance just expired. Can you help me with that? I mean, our hope is that that should never happen. And if we are working together, we can make sure that that does not happen. So I mentioned the ABLE account as an option to special needs trust, but not mutually exclusive. A lot of people think, oh, I'll open up an ABLE account. I don't need a lawyer. I don't need a trust account. ABLE accounts, while I think they are one of the greatest things that the government allowed us to have as parents and as caregivers of individuals with special needs, they still are capped at $100,000. If you have an ABLE account that exceeds $100,000, your loved one will lose their benefits. The ABLE account was developed, it actually was passed in 2014. We didn't really begin to see any available to purchase because they are acquired through investment firms or through your state. Not all 52 states even have ABLE accounts. If your state does not have one, you can get an ABLE account from another state. Just there are some tax deductions, tax incentives that you do get if it's in your home state. But again, that's something, if the state doesn't make it available, it doesn't mean the ABLE account isn't a great resource to avail yourself of. ABLE works very much like a college 529 account. The money grows tax-free. The money comes out tax-free. In Pennsylvania, it is not a payback to the government, which is why we like it in Pennsylvania. But as I said, it is limited to $18,000 per year, not to exceed $100,000. But for the individual who may have a job, who may be working a little bit, and maybe they are getting $1,600 a month from Social Security and $700 or $500 from their job. And now every month they're $100, $200 over the $2,000 limit. Well, if we have $200, $300 automatically being transferred into the ABLE account, one, it's going to take a long time for that to add up to 100,000. Two, they're going to be using that money because ABLE means ability for a better life experience. So our loved ones who are working, who are putting away some of this money, many of them drive, have cars. We all know we need inspections, we need tires, we need brakes. And if we are limited to only ever having $2,000 to our name, well, that's going to be pretty impossible to do. So utilizing the funds from the ABLE account, I have to move. I need to come up with 1 month security. I need to come up with first month's rent. I need to move. I need to buy a new sofa. These are all great reasons to have the ABLE account. We are going to talk about guardianship versus power of attorney. People ask me that all the time. And, we are always our child's guardian until they turn 18. Once they are 18, they are considered an adult. And when they are an adult, we are no longer allowed to advocate for them, talk to their doctors. I will say this, even with our neurotypical children, for those listening in, when your child goes away to college, God help you if they get sick, end up in the hospital, or something goes wrong at the university. The only one that will talk to you is the bursar's office because they'll let you pay the bill, but you cannot call the hospital and find out how they are. Nobody will talk to you unless you have a power of attorney. Now, you can have limited power of attorney. Powers of attorney can be changed when the child gets married or has a partner or a spouse. Guardianship, and again, we are our children's guardian until they are 18. But once they are 18, you actually have to apply to your state to become that child's guardian. And often this can be a very difficult, very, very draining, costly experience. The individual may be very resentful of it. We typically see this when you have a nonverbal, physically challenged, intellectually compromised individual who can't acknowledge that mom and dad or Aunt Holly are going to make medical or financial decisions for them. Even if the individual uses a speaking device, if they say and they truly understand what we are asking of them and we're presenting them with a power of attorney, if they understand that, then that would be acceptable. But if truly the individual has no concept of what they're doing, then the state is going to look for more of a formal guardianship. Okay. Often this does, pose other problems because not everybody has large families, other people, multiple siblings. Not everybody has a spouse. Not everybody has a spouse that they're still with. So, we have to look at alternatives for who could serve as a corporate guardian, a trustee. Are there institutional individuals that can do these types of roles, fulfill these types of roles? How do we feel about it? We'll talk a little bit about that as well. Even in the best of married couples, I hear couples say all the time, my wife takes care of that. I have no idea who my daughter's gynecologist is. I don't know when she had her last appointment. I don't know what medication she's on. Well, you better have a letter of intent, because if something happens to my wife and the social worker comes every month, they come every month to check and make sure that we as her caretakers are doing everything that's right. I mean, I have actually seen the state come in and take the child away from parents who are neglectful, who are not fulfilling the responsibilities that they must do, to care for their child. So a letter of intent would be a great document, and anybody who listens in, if you email or call us, we do have an electronic version that we can send you. And it's an ongoing, you can always update it because medicines change, doctors change, services change, care providers change. But man, is that a great resource to have if somebody is coming in to help care for your child. Even if it's just for a short respite week, instead of rewriting everything, you now have it in a very cohesive place, okay? A lot of people say to me, Bruce, we updated our wills, we have a trust set up, we are good, okay? And I'm going to say, did the lawyer call your insurance company and change your beneficiary for you? Did the lawyer call your HR department and contact your 401k administrator and change the beneficiary for you? The will does not change the beneficiaries. The will does not go to your bank and name your daughter as a TOD, as a transfer on death. If the asset is still given to the child by the estate intestacy laws or left to your estate, which is a complete disaster, because then every state has what I'm saying, the laws of intestacy, they will determine where that money will go, and it will ultimately go to the child with special needs because it's going through the bloodline. And as I said, if that child with special needs has more than $2,000 to their name, they will lose these much, much, much needed benefits. So I beg you to please, let's make sure that we review all of your beneficiaries. And this could even be policies that you may have taken out years and years and years ago. You know, a juvenile policy that my mother took out on my life. And, oh, I forgot about that, right? It's only $2,000. But you know what? That 2,000 with the 2,000 that my daughter's allowed to have will put her over. And I will get charged back. I will lose all her benefits. And it's a real problem.
Bruce, I hate to interrupt for a second, but you just, again, brain alert for me, learned something new after our 50th presentation together. When you mention life insurance, I know that I was always taught, because I do have my life insurance license, I don't sell, but one of the best times to get a policy is for your child, as early as possible, before, things are discovered or whatnot, or they, have conditions like diabetes or, God forbid, anything worse, cancer, as they get older in their 20s, 30s, 40s. Yep. So if you have a child with special needs or a grandchild, right, you have to have that insurable interest, which you can describe. Can a grandparent, because that might be this audience, when a grandchild is born and they know that grandchild is going to have special needs or maybe not, can that grandchild have a life insurance policy on their own life, so that if, heaven forbid, something happened, the parents could use that to bury their child or whatnot? Is that allowed?
Okay, so Holly, you bring up a good point, and I'm going to answer the question yes and no. Okay. If they know that the child has special needs, or it does present a problem, okay, the insurance companies are looking at, when you're buying insurance, it's to basically there has to, well, you already said the insurable interest. Okay, that goes without say if it's a parent or a grandparent, but they look at, well, what, and I know this is going to come out, sounds horrible, but what is the value of that individual? Like, what is the financial loss? And I know this sounds horrible, but that's the way an underwriter is looking at this, right? Many kids with special needs are married. They have their own homes. They have, and so there is a true financial loss if something happened to them. There could be a mortgage, okay, and that could be a financial burden to a parent or a grandparent that's on a fixed income. They would look at these things, but not until the child is age 18. So to your point that, okay, well, as the child's growing, they could be getting juvenile diabetes, okay, well, they might not be insurable. There are some companies that will offer a burial policy for $25,000. They are heavily rated. If the child has any real complicated medical issues, it will be denied. But just because a child has autism, Down syndrome, or cerebral palsy, those are sort of the three things. They will issue a $25,000 policy. But if there are any secondary health issues, they won't. Okay, so it's very limited underwriting. But the other more important thing is that policy that builds cash value and equity is included in the $2,000 limit. So if that policy now has $1,500, $2,000, $2,500, $5,000 of cash, it becomes a problem. The ownership of the policy must never leave the parent or grandparent's name, which in itself causes problems, because if I own the policy on my child and I die, which typically would happen, right? The grandparent would die first, then the cash value is included in my estate for tax purposes. So, Good planning would at some point have me change the ownership to my children, not my grandchildren, right? If I'm buying it for my grandchildren. But if I'm buying it for my child, we would need to then transfer that ownership to somebody else before it would ever go back to her. Does that make
So
sense?
Bruce, then follow-up question, because we've never had this come up, so I'm glad this is kind of our call to share with people. So say Susie Q is born to her grandparents, and Susie Q, grandmom gets an insurance policy right away because she has a good advisor like you to say, hey, this is the gift of insurability that we always talk about, right, for your grandchild. And then a few years after Susie Q is born, you find out that Susie has the disability. She has autism. She has another challenge. So it's imperative then, if your child receives that diagnosis or a late diagnosis, or say has an injury resulting in a traumatic brain injury, or even you look at Brett Favre with Parkinson's now.
Yep.
That was just, he released that yesterday, but there's people that get things later in life and they
Yep.
receive these benefits.
Yep.
I think it's then, Bruce, am I correct in saying it's very important then when your loved one receives that diagnosis?
Yep.
Obviously, it's not the first thing you think of, but it's imperative to speak to your financial advisor or other advisor like your attorney, and not rely on, say, one of these websites like a LegalZoom, no offense, LegalZoom, or other things for this planning to
Yep.
make sure that you don't inadvertently cause your loved one to lose their benefits. Is that what you're saying?
Holly, critically important. And that's where, there are trusts that may need to be put into place, or other vehicles to make sure that the resources don't exceed what the government allows you to have. I mean, it'd be a shame. You don't really want to liquidate the insurance. Look, if the individual doesn't own it, it's not their asset. So it's absolutely not a problem. Where we have to be careful is how the ownership of the policy is listed, because it could say, I'm the owner, but at my death, it will revert to the insured. Well, it can't be that. At my death, it reverts to my wife. At my wife's subsequent death, it reverts to one of my other children. And this is why you'll see, through my presentations, we always talk about reviewing the plan annually, identifying future people to be involved in the care so that we never have this problem. But boy, are you bringing up a good point. And, talk about, athletes and individuals who are suffering traumatic brain injury. We're seeing more and more of that now with our hockey players, our football players. I even had a football coach that developed frontal lobe dementia, and they had life insurance. I mean, these are all people that have worked their lives, right? And now they're faced with, oh my God, I have life insurance with $30,000 of cash value in it. What do we do? So again, this affects everyone, and there are ways to mitigate this. It's just something that does need to be discussed with an advisor who understands it.
So then, Bruce, just adding on just one final point, because this is something you always talk about, is it's very important then when you have these life changes, whether it's a divorce, whether it's, grandparents and a spouse dies, or a spouse goes into long-term care or whatnot, that you really review your beneficiaries and how
Absolutely.
things are set up. You don't want perhaps the ex-spouse or your ex-daughter-in-law or ex-son-in-law to get something that you want your grandchild ultimately to receive. So the planning is imperative, and you sharing everything with your advisor.
The planning is imperative. And remember, in a divorce, if one parent is doing everything right and the other one is just sort of, que sera, sera, I'm not going to worry about it, and they pass, and I know, everybody says, oh, they were a bum, he doesn't have anything. Well, if he has a car, if he has a house, if there's anything more than $2,000, and when I say laws of intestacy, meaning that if I don't have a will, the state of Pennsylvania is going to say that my assets go to my spouse and then to my children. If I don't have a spouse, it goes equally to my children. And equally to my children means that 1/3 is going to my child with special needs. Now, Holly, somebody in a seminar the other day said to me, okay, well, what if we disclaim it? The child with special needs inheritance. Let's disclaim it. And do you know what the state of Pennsylvania says to that?
But
That child then made a gift, okay? They wouldn't have to pay the 4.5% state inheritance tax, but it would be considered a look back from the 5-year look back for Medicaid. And they would say that my daughter made a gift to keep her Medicaid. So it is not going to solve that problem. And that is a huge aha. Other people say, well, you know what, Bruce, you have 3 children, just give her third to the other child, okay? So if one of my other children who are married gets divorced, well, now my special needs child's money just went to the ex-spouse, my ex-daughter-in-law or son-in-law, okay? These are not good options, but that's how planning used to be, Holly, many years ago.
Right.
So we want to make sure, like you said, that these things are updated and re-looked at, and considerations are made for the child now with the special needs to protect them.
Thank you, Bruce. Sorry to interrupt your flow, and to everyone listening, now you know why I call him the guru.
Thanks, Holly.
Welcome.
So when we do work together, we are going to look at all the financial considerations that are available for the family. Whether that individual is eligible for food stamps, electrical assistance, gas assistance, emergency funding, cash assistance. Often we'll find individuals are receiving Social Security, but not the right amounts, not the right type of Social Security. They are leaving hundreds and thousands of dollars on the table. Social Security doesn't come out and ask you, when you as an adult apply for Social Security, while they are supposed to ask you, it's one of the questions on the application. If you're doing it online, usually it's like the 5th or 6th question says, do you have an adult child with special needs? But if you just show up at Social Security and say, I'm here to apply for my Social Security, they may not ask you that question. And if they don't, and you don't volunteer it, your child will stay on their own benefit and never get access to 50% of your Social Security. That's huge. And when you pass, the child gets 75% of your benefit. That is a big difference from the $600 to $900 benefit that the kids are getting on their own. So I urge you to make sure that you take that into consideration. A lot of people say to me, well, Bruce, then my wife won't get it. No, it has nothing to do with what your wife gets. Your wife is either entitled to half of yours or all of hers. If all of hers is more than half of yours, then there's absolutely no issue whatsoever. If your wife or spouse never worked, okay, then they do have a family maximum, and we have to look at, okay, we might reach that, because some of that money is going to be split with your child. But again, that's something that we would look at on an individual basis. And nowadays, most couples do have their own Social Security records. And there are multiple calculations that we do to show you the best way to maximize those benefits. All right, and then finally, how to actually start this process. So I know we spend a lot of time on this slide, but we will go faster as we go along. Okay, so to me, this is my biggest concern. What's going to happen when I'm no longer there? Who's going to look after their best interest? How are they going to be able to afford their future care? And will they be happy? Will they be healthy? Will they be secure? Okay, as a caregiver, that keeps me up at night. Okay. As you're watching this, I want you to think about this, because I don't expect anybody to answer, but have you or anyone else left more than $2,000 to your loved one? This could be a niece, a nephew, single Aunt Mary. Holly and I have done a lot of work with the Archdiocese. It could be, a parishioner, okay, who, again, may not have millions of dollars, right? But has some money, has some assets, some that they want to leave to the child. This is a lovely thing to do, right? We think we do it with the best of intentions. My mother had bought bonds for my daughter, and they were in my daughter's Social Security, unbeknownst to me. And when I went to Social Security to apply, they said, Mr. Sham, you have all these bonds in her name. She's not eligible. And we had to liquidate the bonds, pay capital gains on the bonds, reapply. It was a nightmare. And, we're told that you don't ask people about money, right? You don't talk about money. You don't sit there at Thanksgiving and ask your Aunt Andrea, how much are you leaving Amanda when you die? But, this is what happened. My niece volunteered it and said, oh, by the way, Uncle Bruce, I named Amanda. She's a single niece in New York, professional. I named Amanda a beneficiary of my 401k. And I immediately had to have her go upstairs and change it on the computer to the Special Needs Trust for Amanda, dated August 1st. And here's the tax ID number. Okay. In our documents, have you identified a future care provider? I mean, we find that one of the things that really holds people up from doing even planning is because this is something that they don't have. And we will help you through that. And like I said, there are actually professionals, institutional, corporate individuals that serve in these capacities if you truly don't have somebody to. So let's make sure that we're identifying somebody if we're not there. Okay. And I think we talked a lot about is that dependent listed as a beneficiary anywhere? And again, it could just be by checking a box, children of marriage equally. That was such a standard beneficiary option, spouse, and then children of marriage equally. If that box is checked, even if you have a will, even if you have a special needs trust, I don't care if you spent $5,000 setting up a special needs trust. If that policy says children of marriage equally, it's going to the child. So if you answered yes to any of those questions, okay, please feel free to reach out and we're happy to discuss it with you. Anybody from the organization is entitled to a 1-hour free consultation with us. That is something that we did promise to Melissa when we joined. All right, so we talked a lot about the $2,000. All right, so I'm gonna move ahead on that. Okay, when we look at government benefits, we look at what are considered entitlement benefits and what is truly public assistance. Okay, we also talk about what is provided by those entitlement benefits and what does the Supplemental Special Needs Trust provide. But I think this is a really good slide to understand the difference between entitlement and true public assistance. Okay, we are entitled, we are paying in to Social Security. I never apologize for my child getting it. They earned it. They're entitled to it. We earned it. We're entitled to it. If you've worked and built up a work record, you will get Social Security disability. Social Security supplemental income, if you look to the right, is more for low income if you never really built up that Social Security, but you have a disability that prevents you from being gainfully employed. And again, that's a number that changes every year. That's also a number that is interpreted differently between state Medicaid and the state Social Security guidelines. You may not be over the limit to continue to receive your Social Security, but you might be over the limit to keep getting free Medicaid. I'll say that again. You might not be over the limit to keep your Social Security supplemental income, but you could be over the limit to get your Medicaid. And this is something that we're seeing all the time now. When the parents pass or the parents retire and the child now goes on the parent benefit, they are now having too much income. And by having too much income, they could lose their Medicaid. They could lose their Medicare that's being paid for. They will have to pay for the Medicare. And if they are getting waiver services from their state and they lose their Medicaid is tied to the waiver. This is a real problem. You need the Medicaid to get the waiver, and you need the waiver to keep your Medicaid. So we've been doing more and more appeals, and it's been very, very difficult process. So you want to make sure that nothing happens to jeopardize that. Okay. Entitlement benefits might be spouse and survivor benefits, what we call the DAC benefit, the disabled adult child benefit. Medicare is an entitlement benefit, okay, versus SNAP, your food stamps, your supplemental nutrition program, your temporary assistance program, your LIHEAP for utilities, or the children's CHIP program, healthcare.gov. Every state has their own children's Medicaid program. Again, I don't expect everybody to remember all this. I want you to just know that these are all things that special care planners are versed in and study, and we are constantly being updated. We're constantly every year going for continuing education because things change, as we all know. All right, so what are some of the solutions? We talked a little bit about special needs trusts. I told you that there were 4 types of special needs trusts: third party, first party, pooled, and Special Needs Trust Fairness Act, which is a self-settled trust. If Aunt Andrea leaves me that money and I now am about to lose my benefits, as long as I'm under the age of 65 and I have the capacity to say, hey, I can't have that money, I want to put it in a trust. I understand that when I die, to the extent that I've received more money from Medicaid than what Aunt Andrea left me, that anything that's left in my trust is going to get paid back to the government. But if I am receiving a day program, transportation, job coaching, okay, 24/7 nursing care, I assure you that I received much more from the state than what might have been left to me by Aunt Andrea. And again, we have seen people leaving millions of dollars, but think about the cost of these programs, upwards of $250,000 a year. That's going to get used up real fast. Okay. The issue here is that if the individual with special needs is over age 65, they can't set up this self-settled trust. You can't set up a first party trust if you're over age 65. So part of the planning is this discussion as to what is going to happen. And we do need to begin to find out, what do other people that are tied to that individual, what do their plans look like? Again, sometimes it's not always the easiest thing. If I'm calling an ex-father-in-law who is making gifts and I'm saying to them, look, your grandson is awesome. No, he doesn't. It's my daughter-in-law. She's the crazy one, right? How many times do we hear that? And I'll call back 2-3 times and say, please, you want to give him the money? That's great. Here's the trust that your daughter set up. Here's the tax ID number. This is where it needs to go. Okay. We really want to look for third party trust. Third party means it's not the individual with special needs. Okay. It's somebody else setting it up for them. That trust is not a payback trust. That trust can then get paid to my other children. It can get paid to organizations, nonprofits, churches, okay? That's the kind of trust that we want when planning is done properly. Money for the child is left to a third-party special needs trust, okay? Pooled trusts are when you're over 65. I had a 70-year-old woman who was hit by a bus, got a settlement. It had to go somewhere, okay? But pooled trusts don't necessarily pass to the family. If a charity has a pooled trust, a residential program has a pooled trust, a state has a pooled trust, typically they are payback trusts, and that money, if it's not used during the loved one's lifetime, will get paid back to the state. So again, it's great that these things exist, but we obviously always want to try to plan for what is going to be best. Okay, let's talk a little bit about funding trusts, because people say to me all the time, Bruce, I don't need a trust. I don't have millions of dollars, right? Well, we don't expect you to have millions of dollars. Like I said, anything over $2,000 requires that money goes somewhere. And if it's over $100,000, the ABLE account isn't going to cut it. And remember, the ABLE account, if the market is good, can be earning interest and exceed that 100,000 without you putting more money into it. So you want to be mindful of how the market is doing and how that account is growing. The special needs trust is there to protect you, to protect the benefits. But how do you fund it? Okay. A lot of people say, well, I'm going to put my house in there. Okay. Well, what if before I die, I need to sell that house because I need to go into a nursing home? You know, what do they say? The shoemakers' kids are the ones that don't have any shoes, right? Like the caregivers, they suffer the worst because they don't take care of themselves. We're busy taking care of everybody else, and we think of ourselves last. Okay, if I have to sell my house so that I can go into a nursing facility, I better make sure that I didn't put it in an irrevocable trust that I can't take it out of. Investments. One, I might need those investments for me to live on, but two, those investments earn money. And if the investments, the way they are going to pay out, are going to create too much income and taxes, same with retirement funds. You know, when the law changed during COVID to the Job and Tax Cut Act, we are no longer able to stretch the money over our lifetime. It has to be spent over 10 years. Now, there is a little caveat that if it is going to an individual with special needs, they could still stretch it out over their lifetime. But how are they going to manage it? What kind of income is that going to create? You know, trusts pay the highest income tax rate, 37%. When we are leaving assets to beneficiaries, I don't have to leave 50% or 33.33% to each of my kids. Okay. One, fair doesn't have to be equal, but even if I want to do it fairly, I don't have to leave a third of my house, a third of my IRA, a third of my life insurance, a third of my car. I can say my assets are worth $1 million. I want to leave 333,000 to each of my kids. Well, my child with special needs, life insurance, liquid, unencumbered cash is really the best to leave to a special needs trust. And Holly started to bring that up. Okay. Yes, an individual with special needs can have a house. For those of you who have studied Medicaid, you can have a house, you can have a car. But here's the problem. I leave my daughter the house. After 3, 6, 9 months, she can no longer maintain that house. It's too much of a house for her. The air conditioning is breaking. The roof is leaking. The washer and dryer need to be replaced. And she sells the house. They sell the house. The entire proceeds from the sale of that house have become an available resource to her. So now, even though she was allowed to have a house, she's lost all her benefits. And now, and I don't care if it's worth $500,000. I don't care if it's worth $1 million. She's going to have to spend that money before she can regain her benefits. I will also tell you that there are thousands of people on waiting lists for these benefits. If you lose it, you are on the bottom of the waiting list. It took years for my daughter to get one benefit, $1 of benefits. Okay, years. And that's with me being alive and advocating for her. You don't want to lose those benefits. Okay. All right, let's look at, we talked a lot about ABLE accounts. In 2026, they are going to raise the age because we talked about how mental illness, addiction is now a disability. Well, often that might not have happened until after age 26. So right now, the way the law is written, the disability must have occurred before age 26. And again, remember what I said, that the states monitor this. In Pennsylvania, in 2026, the law is being changed that the disability had to occur before the age of 46. So it does give us some latitude, but it certainly didn't help me with the 70-year-old that got hit by the SEPTA bus, even though she was born with the disability. Okay. The disability has to have onset prior to age 26. All right. And again, I think we spoke enough about ABLE accounts. Again, anybody has questions, they're welcome to reach back out to us. This slide I guess needs to be updated because it goes up with the gift tax limit. In 2023, you can gift up to 17,000, an additional 13,590 if you're working. This year it's 18,000 and an additional 14,500 if you're working. But remember what I said, even though the state allows you to put in 235 to 550, Medicaid, if it exceeds 100,000, you will lose the Medicaid, okay? It cannot exceed, okay? It cannot exceed 100,000 or you will lose your Social Security, okay? And again, this does contradict itself because I know it says it does not affect Medicaid. Depends on the state and it depends on the situation. Income versus resources. Income versus resources. And if you have a waiver versus just Medicaid, it's going to have another factor. So every state has different regulations around this. So I beg you, let's look at it before we just make a decision there. Okay. Have you identified that future care provider? Okay. We talked about the difference between guardianship and power of attorney. If your loved one is able to say, Mom and Dad can make financial and medical decisions for me. I had a little boy today say it with an iPad, the speaking device. He understood what he was doing. He programmed it. We had the notary there, and he signed his powers of attorney today in my office. Okay. He couldn't say, yes, Mom and Dad can be it, but on his iPad, he was able to speak it, program it, and we feel very comfortable with it. Okay. Power of attorney is giving us permission to act. Guardianship is taking all rights away from that individual. These are very difficult conversations, but remember, once your child is over 18, you are no longer their guardian. You're no longer able to talk to doctors, act on their behalf without a power of attorney. I can't even open up an ABLE account without a power of attorney. And is the child capable of opening that themselves? Again, those are calls we get every day. Bruce, we just lost it. We had too much in the account. I don't have a power of attorney. The child is not capable of opening up the ABLE account. It's a real problem.
So Bruce, I hate to interrupt, but now you're bringing up something again that I didn't think about was, so if heaven forbid you don't have the power of attorney because things happened or whatever,
Yep.
and you had to go to guardianship. As a guardian, and I know every state's different, but in your experience in Pennsylvania, is a guardian permitted to open the ABLE account, or does that have to be part of the court order appointing guardianship?
Well, no, the guardian can, but that doesn't happen overnight. And
Right.
Meanwhile, you just lost all your benefits and you're like hysterical to get them back.
Right.
And you have to submit to the state everything that you're doing as a guardian for an individual.
Right.
Right. And quite frankly, the state may not want it to go into an ABLE account that's not paid back to the state if
Right.
the individual is, you know what I mean? Even though if you have an ABLE account in Pennsylvania, it's not considered a payback resource. If I'm now doing it as the guardian and I'm reporting it to the state may say, you know what? No, it's got to go into a first party trust that is a payback.
Got it.
Right. Or to the extent that we have given money to you, we want to recover that money. Again, why it's so critically important to start having these courageous conversations to make sure that things don't happen when we're gone and then we're getting the hysterical call, right?
So before we get to the letter intent, which is critical and it's one of my favorite parts, everyone says different things. I know in Pennsylvania we have a huge backlog for individuals with special needs needing to sign up for their benefits. But if you had your druthers, if a grandparent is listening to this, a loved one, a parent, and loves someone with special needs and wants to help make sure that their planning begins so that they don't miss the cutoff where you can't help them. Mm-hmm. Ideally, what is the age, Bruce, if Susie Q has special needs? She's a child. What is the age that you begin? Is it right if they're born, right at the diagnosis, even if the diagnosis is at 4 or 5 years old? When is the perfect time in your experience if you can.
Okay. So one of the benefits that we have, if you're an elder and you're looking to qualify for Medicaid, there's a 5-year look back. Okay. So a lot of people think, well, if age 18 is when we can apply for these benefits based on the child themselves, not based on the parent, do we have to do it at age 13? Okay. For purposes of a special needs individual, there really is no look back. Okay, they're not looking at that. It's not a look back if you're doing it prior to age 18. Okay. Look, I think it's important to have the language in your will that anything being left to that child will go into a special needs trust. If there's no money today or nobody's really leaving money, like this is the other thing, Holly. If I have a trust that's set up in my will, when I die and my wife dies, the trust gets set up. Well, what if my mother dies first and she wants to leave something to my daughter? My trust doesn't exist yet. Okay. And you don't want, and then let's say my son is the trustee, you don't want to have that individual managing 16 different trusts because Aunt Holly's left the money and Aunt Andrea left money. And you know what I mean? So it's better than at that point, and we always ask, are you expecting anyone to leave money outright? Because if so, we can't have a trust that's set up in your will. We need what we call a statutory document that's in existence today with a tax ID number. And my mother now can say that this money that she wants to leave to Amanda is going into this trust. Here's the tax ID number. Here's the date. My mother doesn't have to put the money in today, but it's identified that when she passes, that's where it's going. Okay. But if it's a trust that's in my will, it doesn't exist yet. So that is really, really important. Okay. If I don't, and remember, the laws of intestacy say if I don't have a will, that half is going to my wife and the rest is going to my kids. I don't think my wife would be real happy with that if she was only getting half. Typically their spouse is getting everything. And then when she dies, it gets divided equally between the children. In my will, I have it set up that my daughter with special needs gets 60%. The other 2 children only get 20%. But when my daughter dies, her trust gets divided in half between the 2 other kids. There's no cookie cutter answer for the best way to do this. It's all based on the family dynamics, right? Maybe I helped my daughter buy a house with an in-law suite so that while she was alive, my daughter could live with them. Okay. Well, obviously then she got money from me during my lifetime. And it isn't fair that she would get more when I pass. All of these things are addressed, Holly, when we work with families. Does that answer the question?
It does. It does. I know that that's probably a question that some people have. So sorry to interrupt you. Keep going.
Okay. Yep. I know we're sort of running to the hour here. So we talked a little bit about the letter of intent. Again, this is a working document that we can send. I do have it hard copy if listeners prefer to have, they don't like to work online, but by working online, you can update it all the time and not just scratching out, whiting out. But this booklet is really a nice piece to update with who the care providers are, medication, doctors. Look, it's very frustrating when the doctors retire. For those of us who are parents, the pediatricians, once they are no longer able to service our children, to start with a new doctor who doesn't really understand children with special needs, it's very, very difficult. I'm thrilled now that many pediatric groups are bringing in what they call developmental pediatricians and pediatricians that will stay with the child for life. But apparently, what I've learned is that many pediatricians, their malpractice insurance only covers them till the child is 25. And that's why a lot of the children's hospitals won't continue to see the children. Look, I don't think a lot of our kids are safe in some of these hospital environments. If they want to put my child in a psych ward, okay, she would die in a psych ward if she was suffering from mental illness. Okay, we had to put her in a neuropsych ward so that I could stay with her. I mean, people would never have thought something like that, but she did have a breakdown. She did have a breakdown in addition to her intellectual challenges. And they wanted to put her in a psych ward. And I said, absolutely not, where I was not allowed to go visit. she would absolutely gotten eaten alive in a facility like that. So it's very important that you have these things identified so that somebody knows. Somebody has to be the advocate for that individual. Okay, and I think we talked a lot about this, about listed as a beneficiary. Just think about all the places that you might have a beneficiary. And I'm just constantly reminded of my wife that, when she was a school teacher and we were getting married, they gave every teacher a $2,000 life insurance policy that they kept even when they retired. And as your life goes, I'm married 47 years, $2,000 policy you forget about. But the beneficiary was me if living, and otherwise the children of our marriage equally. Again, even though it's only $2,000, a third of $2,000 might put Amanda over the $2,000 limit. And so again, we're thinking, okay, that's right. We have to even go back to that one little $2,000 policy and make sure Amanda's name is not there, but that the trust is there in her place. So in summary and in review, let's please make sure that we're looking at beneficiaries, we're updating them. I know somebody said to me earlier today, well, there's no place on the Vanguard beneficiary online to name the trust. And you know what? There isn't, okay? But I think we all have forgotten that we can make a phone call and there's a form. We're so used to doing everything online, everything DocuSign, everything digital. There are forms, okay, that are specifically designed to make these accommodations. And it just requires us to call together and give the verbiage so that, again, the benefits are set up properly. Okay, let's just see here. I guess the last thing in the few minutes that we have left to talk about is the caregiver themselves. Again, on an airplane, they tell you to put the oxygen mask on yourself first. I've spent the last hour talking about how to take care of the loved one, right? I often worry if I am the primary caregiver for my daughter, okay? And, I haven't even gotten into the fact that my wife developed a debilitating illness recently. Okay, so now I'm caring for two people. What's going to happen if something happens to me? Okay. One of the things that's fascinating to me is how insurance today can reverse engineer to actually serve as a long-term care policy and not just a death benefit. Didn't exist when I started, when I got married, I'm married 47 years, but we have even seen group insurance carriers for some of our clients that have debilitating illnesses, Parkinson's. I speak to Parkinson's groups, I speak to ALS groups. We can go to your benefits department and often, again, and it's different depending on the carrier. Some individual insurance companies will allow you to accelerate 80 to 90%. The group benefits maybe are 25%. But 25% of $1 million is $250,000. That's not an insignificant amount of money to bring forward to help with care, to help putting in a Hoyle lift to get me into that bathroom, to put in bars in the shower so I don't fall. Okay, but these are things that people don't think of. Okay, then people say, well, when I got disabled, I had to leave my job. Okay, and they never thought to convert their life insurance under waiver of premium, so they're not going to even pay for it. And then this way, accelerate the benefit on that policy. So again, Holly, when you say, when is the right time to do this? I think as soon as the diagnosis is made, particularly for a debilitating illness and you're still working and you haven't really let HR know, or, let's see what benefits are there, right? Often once you're diagnosed, you can't obviously get these benefits, but if you're working with a big company and in November, it's open enrollment period, you better believe you want to look at maybe accessing some of those benefits if you're allowed, if you don't have to prove insurability, okay? And if it is written such that everyone is eligible and can't be discriminated against. Very, very important. So now, if anybody's listening now at the end of the year, these are things to take under advisement. I can't tell you how many times I hear, somebody in their 50s suffered from a heart attack. No possible reason why that should have happened. They're healthy, they're in good shape. But, you know, sometimes what we eat, sometimes our genetics, and I have a friend right now, he's 49 years old. He has no disability insurance. And you know what the irony is? He works for the Veterans Administration helping disabled veterans get benefits. He will not get Social Security for 6 months. This is the most tragic thing I've ever seen in my life. And his company offered benefits and he didn't take it. These group benefits are so inexpensive. Shame on you if you're not taking advantage of it. Okay. All right. So that, you know, this long-term care, there's so many different types of long-term care now. Again, it's something that we're very happy to help you with. So Holly, to your point, how do you start? You know, when we work with somebody, we identify a special needs or elder care attorney that is well-versed in this type of planning. I get very nervous. Well, like you even said it, LegalZoom is not going to cut it. Even some of the free legal services that are offered by reputable, you know, companies, if they do not understand special needs, I am not comfortable with the trust that's been drafted. And I do have one of our partners who are special needs attorneys take a look at it and see, will it hold up in Pennsylvania? Okay, will it hold up in that respective state? And then working with an advisor, you know, everybody has an advisor, but does that advisor understand the special needs process and how things need to be set up? So I hope that that's gotten everybody thinking a little bit. I hope that everybody realizes that there is a light at the end of the tunnel, that these things work very well when the plans are in place. It's always a pleasure when we have plans in place. Working with some of these corporate guardians, these trust companies, where today, while I'm alive, I can speak to the person who's going to be overseeing my daughter's money when I'm gone. That gives me tremendous comfort, knowing that somebody knows what I would want for her, that appreciates our value system, has met my daughter, and I almost feel like I'm navigating her care from the grave. So on that note, Holly, I'm going to turn it back to you.
Yeah.
If
So
there's
Bruce,
any
I think,
closing thoughts or comments.
yeah, so I gave a presentation that any of you can also watch in the library. It'll be right after Bruce's, about how to choose and not choose decision makers. And one of the things I mentioned is the National Association of Elder Law Attorneys. So for the state that Bruce and I are in, Pennsylvania, on average, I think I mentioned in my presentation, attorneys routinely fail the first 2 to 3 times. Because the process is so stringent. And for all of the attorneys we have in Pennsylvania, Bruce, still it's just over 100 now. Over 100, that's it. That's specialized, that can have the elder law attorney designation.
Wow.
So if you don't see them on the NAELA website, NAELA, if you Google it or whatever search engine you choose, you will see if someone says, oh, I'm Susie Q, poor Susie, if I ever meet a Susie Q, I'll forget. But poor Susie Q, you know, she says she's an elder law attorney, but she's not on the NAELA website. Also, to Bruce's point, there's something called the Special Needs Alliance. Use your favorite search engine and search by SNA, Special Needs Alliance. And then for financial advisors like Bruce. So something very important is something called broker check. And an advisor should never be afraid to tell you about broker check, which tells you anything they have in their file. Are they in good standing? Sometimes, Bruce, I know you've earned all of those letters after your name, but sometimes people say, oh, I'm this or I'm that, and I'll check the website for that designation, and they lost it. And so that's important. But you shouldn't have someone for especially, and of course, I'm very biased towards Bruce. That's full disclosure because I think he's awesome. But for a special needs advisor, what would you say, Bruce? Should they have at least 5 to 10 years of special needs advisory? And
Again,
maybe
Holly,
more than that in the industry?
If they're working collaboratively with a special needs advisor, I would feel good about that.
Okay.
But somebody who does, you know, And so again, I've been meeting a number of young new advisors who are attracted to the profession because they have a sibling, with special needs, or their spouse is a special needs teacher, and but they know to work collaboratively with somebody who really understands this, and isn't just trying to fly by the seat of their pants. No,
Right.
but so I don't want to just say no,
Okay.
everybody should wait, but I would want to know that they are affiliated with somebody who is licensed, that their firm is committed to this type of planning, their firm understands this type of planning, because if they don't, okay, then that's a problem, right? If I found out that, in an investment company's website, there wasn't a form to address a special needs trust, that would be a problem. That would be a big red flag to me, right? I mean, that would be a concern for me. But I think everybody would respect it and understand it, and make those accommodations.
No, I agree. So thank you everyone for joining us. You who will see the recording of this. And then as you watch this, if you watch this before November, I think one thing we can all agree on, Bruce, is in this, our least favorite time of year with all the political commercials, even if you like the person, we cannot wait for this political season to be over.
Yeah.
And Bruce will have a great presentation about a week and a half after Election Day. So who wins? We are not going to speculate. That is not our goal. And thank goodness it is not. But thankfully, there's by the time Bruce gives his presentation, those commercials will be over. Hopefully we have a winner. And Bruce will share with all of his training and all of the experts that he has access to, what does that person's election mean? That does not mean it's political in any way.
Right.
It's about your money and your planning. And obviously, if choice one gets in, that impacts your family one way, or if choice two, I'm not saying who the choices are, they get in, then that impacts your family possibly a different way. So we thank you for your time today. We know we went a little bit over, but I think you can all agree that Bruce was worth it with great information. He is on the website and his information is in the slides, but his email address is B as in boy, Sham, S as in Sam, H as in Harry, A as in Apple, M as in McDonald's at financialguide.com. And if you use your favorite search engine to search for him, believe it or not, he pops up everywhere. So thank you all. Thank you, Bruce, for giving so much of your time as usual. We love being contributors to this awesome new organization. And let us know what you would like to see in 2026, and we'll do our best to provide it. Thank you so much, and have an awesome day or night whenever you watch this. Thanks. Take care. Bye-bye.
Thanks, everybody. Bye-bye.